Mr. Binczak, good morning.
Good morning. May it please the court. This case has had a very lengthy procedural history, and it's a pleasure to finally be before this court on this matter. Mr. Fredericq was subject to 7 days of unwarranted, unlawful tracking of his physical location. This wasn't just a case where cell site location information was being collected. Rather, this was a case where his real-time location was being identified by the cell phone company engaging in his cell phone every 15 minutes, pursuant to an order that was made out of the Brockton Superior Court. That information was not collected in the ordinary course of business for the cell phone company, and it would not have been collected in the ordinary course of business. It was collected purely at the behest of this court order for Detective Williams. I'd suggest at this point that the appeals court, the trial court, have appropriately found that this tracking was unlawful and must be suppressed, and I suggest the Commonwealth has agreed with that. I would like to start by addressing the appeals court decision, which essentially affirmed the trial court's decision, however, found separate grounds in which the cocaine in a crawl space should not be suppressed. I suggest that this involved a wrong application of the fruits doctrine. The fruits of the poisonous tree doctrine requires that all evidence that is obtained in violation of the Fourth Amendment or Article 14 not be used at all. The Supreme Court has made it clear, not being used at all does not simply mean not being used in a court proceeding, but it may not be used at all by the government. And this is a case where we see the dangers of the unlawful tracking, unlawful tracking of individuals to their cell phone. Because a small step at the beginning can result in a snowball of illegalities, and I suggest that's what happened here. When Detective Williams started tracking when he was looking for his suspect and started tracking of this phone, they anticipated, based on their information, that they would be discovering this phone somewhere in the vicinity of New York City. On July 2nd, they received subscriber information for the phone, and all that identified was Stanley Fredericq and his address of 220 Howard Street in Brockton. Separate from that, they were receiving the results from the live pinging that was being done by the cell phone company every 15 minutes. So on July 2nd, having received that information, they saw, the first ping showed the vehicle on the western side of New York, which was consistent with traveling to New York, but they then noticed it continued to travel south past that.
I think we know basic facts. So one thing I don't understand about the appeals court decision, how did they find attenuation? Because the pings get you to the house, right?
Correct.
So where do they find the break? Is it that I do have a little trouble understanding why it's attenuated. I mean, I understand your argument is it's not, but what does the appeals court rely on to find attenuation there?
You know, I feel that the court simply abandoned the attenuation doctrine, but instead ignored it and essentially found that because it found that there was no expectation of privacy in the crawl space in its application of the Thomas doctrine, that therefore that the attenuation analysis falls aside, and I suggest that that's wrong.
We can still... The appeals court writes, the Commonwealth argues that the defendant's statements and the subsequent discovery of the evidence are admissible because they were attenuated from the initial illegal search of the CSLI. We disagree for the reasons stated in Commonwealth versus Estabrook. So, best I can tell, the appeals court did not find attenuation. The appeals court said there was no reasonable expectation of privacy, so that if it were a search, it would be a fruit, but because it was not a constitutional search, then it therefore falls outside of any prohibition.
Correct. That is, and in my view, that is abandoning the attenuation doctrine, because I think when you look at the attenuation doctrine under the fruits analysis, the question is not whether or not the ultimate discovery, whether or not there's a reasonable expectation or privacy in the ultimate discovery. The question is whether or not that discovery can be shown to be attenuated from the illegality. I think, for me, the Commonwealth versus Lottie is the perfect example. The ultimate evidence that was suppressed there was the voluntary testimony of an independent witness. There's no other doctrine, there's no other theory that we have which would allow a defendant to seek to suppress the voluntary testimony of a third party. So when we look at what's being suppressed there...
I'm not sure you've answered the Chief's question, though. I'm confused. Is the appeals court saying that even if there's no attenuation because there's no search? Even though if you got to the place based on illegal searching, if there's no search at the location, all that attenuation goes away. Is that what they're arguing?
That's how I understand it, Your Honor. I mean, because it seems that there is no longer a discussion of how that search, how the conduct by those officers there was divorced from the illegal information they had gained through the unlawful tracking.
Well, you can take the facts, all the facts, and we do need to get to the Jones-Parnell issue that's in this case as well. But you take all the facts and take the crawl space and the expectation of privacy. We can take a look at that as it relates to the intervening event issue when you're dealing with attenuation, as to the flagrancy of the violation. There are facts that have been found, and whatever the answer might be, we can take a look at the consent. We can take a look at whether it's divorced from enough because of the 2703 warrant and what that says about the wrongdoing of the police. So there's a lot of facts that we have here to apply to the attenuation doctrine if the crawl space is indeed an area that there is an expectation of privacy.
I agree. I absolutely agree. I think there is a discussion to be had on whether or not that discovery is attenuated or not. My reading, and I suggest I agree with Justice Kafker's question, is I read the appeals court is essentially suggesting, because they find that essentially no search has occurred in a constitutional sense there, we don't need to apply the attenuation doctrine to that specific search. And I would argue that that's wrong. I would argue.
So it's basically that the appeals court's saying, well, look, it interrupts the analysis, essentially. And you're saying, no, it doesn't. The analysis continues just because there's no search. It's still a fruit of the original search. Is that what it is? Correct.
Okay. Yes. And by the way, I disagree that it's not a search, but that
I know that. I understand.
You know, and this is where I go back.
Just to be clear, you're saying that if they had, because of the CSLI, happened to locate somebody and speak with them, no search, just a voluntary discussion, that the result of that discussion would also be a fruit of the CSLI?
In this case, yes. And the reason is because of the breadth of the unlawful conduct by the government and the way that every single piece, every investigative step that was taken, particularly by Trooper Telford, because he's the one who was focused on the drug investigation here, while Detective Williams was focused on finding his murder suspect. So particularly with respect to the steps taken by Trooper Telford, and his interest now in the drug angle on this case was all built upon that. And it was step by step. It wasn't, I don't think you get, say, illegal tracking of Mr. Fredericq's cell phone and then jump to July 8th where they're searching the home. I think you look at each single day and you see how each day their conduct is a further, essentially is building up further upon the unlawfully gained information they had the first day. First, Telford would have zero interest in this case to begin with because he had information that there was suspects going down in a Toyota rental from an unreliable informant. From an unreliable informant, he was told he had 2 suspects or 3 suspects going down in a Toyota rental vehicle to Florida to pick up some drugs. That wasn't enough for him to act on, and he didn't think that was valuable information. When he learned from Detective Williams that he now had his suspects, and he identified them going down and specifically in a brown Toyota RAV4 vehicle. Actually, I'm sorry. Detective Williams did not know that at that point. Detective Williams knew that his 3 suspects were no longer going to New York, but appeared to be heading to Florida. Detective Williams, then using that information, the unlawful pinging, then learns that his suspects are in Georgia. He's in touch with both the U.S. Marshals and with Georgia officials. He then learns that they are in Florida, and he gets in touch with Sunrise Police Department, who put eyes on them for him. Based on that, they are now able to identify the vehicle, the registration of the vehicle, which they did not have before. They're able to identify the 3 occupants of the vehicle and get physical descriptions of them. And they learn about the details of their activities and their whereabouts during.
So let's talk about when they were able to do that.
Yes.
Because it goes to attenuation.
Correct.
They were able to do that 6 years before Augustine, right?
Correct.
Okay, so when you look at the flagrancy of the violation and you look about this police misconduct, look at how they got this information, we have to take into account this is 6 years before Augustine when we apply from the facts we have the attenuation doctrine.
Well, I think there's a few layers on this. First, I don't think we even need to get to Augustine in this matter. I think we have a violation of his constitutional rights under classic Fourth Amendment analysis, just as this court found in Connolly. This is not a case where they're simply getting cell phone tower data. They're actively engaging with his actual phone. That's how this process works. So they're going into his phone. There was testimony, and it was found by the court appropriately, that when they do this, they're using his battery power. They're actually going into his phone, performing a function which then sends data back to the cell phone towers, and that's how they're getting this information every 15 minutes. This is not Augustine, where they're simply getting the tower data that's collected in the ordinary course of business with a tower.
Were there any, do you know what the status of the law was in any other jurisdictions or federally at that point?
Well, no, at this point it was evolving case law. It was traditionally being analyzed under the grounds ultimately found by Augustine. However, there were numerous courts in analyzing aspects of GPS searching, kind of as this court did in Connolly. You know, this technology was new, so people were figuring out how to phrase it. There were cases, as this court found, looking at, you know, intruding on someone's physical vehicle and recognizing concepts of essentially trespass. A lot of the federal case law talked about it in the context of trespass. And I think we have that here as well. And I would add that that the appeals court also addressed, and I think correctly so, addressed also the quality of the quality of the information provided in the affidavit to at least get a subpoena here. And it found that that did not rise to the level of probable cause. So even though there was an attempt to engage in a procedure, the information they provided was vague and limited and did not come anywhere close to the type of information we would expect to establish probable cause.
You're talking about the underlying 2703?
Yes.
Didn't have to establish probable cause at that point in time. It's 2008 we're talking about. So isn't it disingenuous to say that it didn't establish probable cause when, as a matter of law in 2008, statutorily, it didn't have to?
I don't think it's disingenuous. I'm suggesting that to the extent Your Honor is considering whether or not this is something that warrants whether or not a good faith exception should apply, which we do not recognize, or whether or not this is a case that calls for the exclusionary rule, I would suggest that given that even under our classic understanding of police conduct here, we have a search within a seizure within the Fourth Amendment context, and that should have required probable cause. We don't have that here.
Could it not also have been determined at that point that that would have been third-party information? I mean, Carpenter hadn't come down, none of that stuff.
But it's not third-party information. If they're going right into his phone to get it and create it, see, that's a different.
I see what you're saying.
See, this isn't.
Right.
I would acknowledge.
It's different than the CSLI. Yeah.
So that to me, this is particularly more invasive. When you go into someone's phone and you're live tracking them. I mean, his cell phone company is now acting as a tracking authority for the state police.
That makes them an agent.
Yeah.
Could I ask you about the crawl space for a moment?
Yes.
As far as the factual predicate to be able to determine whether or not there was a reasonable expectation of privacy, is there anything in any of the underlying hearings, even Judge Walker's findings, that would allow enough information to be able to make a determination on the crawl space?
Well, I think his finding would actually more support our view that it was a second and third floor apartment. I mean, if you look at, if I may just step back and then I'll answer that as I go further. I think one of the problems is because no one argued this below. Right. So this was not a distinction that anyone was looking at below. And I looked very carefully at the testimony of all witnesses in connection with this. The appeals court testimony seems to be premised on Trooper Wall's description of how he walked up, essentially. And he simply is describing, and I think this is important, he's describing, and I suggest from a physical layout of whether or not he had an obstructed or unobstructed path. Mm-hmm. On pages 56 through 60 is where he's really describing what happens as he ascends this rear staircase. And I think what's important there is I'm trying to understand, is he walking up some rear staircase where it's completely open, first floor all the way to the third floor, and there's no obstruction whatsoever as he goes from the first floor to the third floor? And I don't think that's clear at all, because what he suggests is he goes up to the second floor, and he says up to the second floor there's a landing area. And it's not clear there whether there's an open door to that landing area that he walks through and then goes into it and is able to either go into a kitchen or then go from that space further up the stairs. Judge Walker, on page 5 of his decision, actually makes it clear, and the way he clarifies it is, they were able to walk unobstructed within the second floor apartment from the second floor to the third floor. And I think Judge Walker's focus on that was merely to establish that the third floor was not an independent apartment. This wasn't a situation where the police had entered a third floor apartment and were knocking on Mr. Frederick's door without having gained consent to enter the apartment to begin with.
And along those lines, does that create a Jones-Parnell problem for the appeals court holding? Do they really have a factual predicate?
I don't think there's a factual predicate, but I don't even think this court needs to reach that, because I think even stepping back from it, even with what's described on the record, this is his bedroom. This isn't the outside door to his apartment where there's a common hallway that is shared by different units. This is his bedroom. It is right outside of his bedroom. I suggest this is a closet. And the testimony was also very clear from the first floor tenant, who explained, I'm not allowed to go up there. That's the deal. That's the arrangement up there. The second and third floor is a landlord's apartment. I have no control of that space. I don't go up there at all. She suggests there actually was a door to the third floor. I think it's confusing and unclear, right? But she actually suggests that there might be a door to go to the second and third floor area from that rear staircase. But I also, since you're asking this, I also think that this court has never suggested, even under Thomas, that simply because someone can physically get from point A to B, that makes something a common space. It's never at all suggested that. There's always been at least some suggestion implicit in this court's opinion that we're looking at also how the space is used, and that's also being viewed at in the context of the evidence. How is this being used? How are the tenants using that? And, I did not brief the Thomas issue because I did not think that the facts of this case require you to reverse Thomas in order to give me the result I'm asking for. But I'd at least like to suggest how that CPCS raises an important argument that I think is sort of present here.
We'll hear from Mr. Levin in a second, and I'll give you a chance to respond. But let me just walk you through it, okay, a little bit. So, appeals court says that is not a search. It's not a constitutional search. Let me just, the entry into the first floor apartment, which is where they began, was consent.
Correct.
So you agree that, but for the consent, that would be a search.
Correct.
Of the first floor.
Correct.
Second floor, they speak again to the tenant, and assuming that the first floor tenant does not have the authority to authorize them to search the second floor, that too is a search, but it's authorized by consent.
Correct.
Okay. Third floor, where the defendant was residing in the bedroom, he authorized them to search the bedroom, but for that consent, it would be a search. Appeals court said, well, it's not really a search because they're entitled, it's a common area and it's not, they could have done that without any consent. Is that?
Well, I'm a little confused because they're recognizing it's his bedroom, and I don't understand how his bedroom can be considered a common area.
But was the area, I thought the area of it was just outside the bedroom.
Correct. There's an area right outside.
In sort of a common area, sort of a living room type area.
Well, a vestibule is how I think it was described.
Okay.
Which sounds to me like a classic attic space with some bedrooms off of it. And again, this is where for me, when I hear someone's bedroom is off of that hallway, that to me doesn't sound like the hallway in an apartment building, right? I mean, that to me sounds like that's part of the apartment. They're also identified, there's no bathroom up there, and I think that's consistent with him being part of the second floor, that it's the second and third floor apartment. His bedroom is up there, the bathroom is on the second floor. And if I can go back, even if it was open, pretend, I don't agree that the facts set that up, but let's say this was completely open. There's a rear staircase that opens all the way up to it. I don't think that changes the analysis at all from what I'm advocating. That is still, I suggest, a protected space and part of his apartment because the tenants have told you how they're allowed to use it. And, where people engage in converting space now to make some extra space in their houses, whether they want to convert an attic room into a finished room or a basement into an in-law apartment, we should not be turning the analysis of whether or not someone can physically walk or access a space within that building is determining whether or not it is a constitutionally protected space. When we have clear evidence of how it's used that shows that it's constitutionally protected, or at least understood to be constitutionally protected by the people who are using it. And that's how all the occupants are using it here. Whether or not the police could walk from the first floor to the third floor, the first floor tenant did not. The first floor tenant understood they could not. So for the people who are living in this building, this was understood to be part of the second and third floor apartment, which was a single apartment, and that was their space, not accessible to the other tenants. The only other tenants in that building was the first floor tenant, Ms. Rawls, and her family, and she made it clear they can't go up there. So I also think focusing on the layout is disingenuous only because you can't divorce that from how it's allowed to be used, and there's zero evidence to support the contention that everyone in the building had access to it or that everyone had free reign to it. But again, if I could step back, I stated this rather facetiously almost in my brief, but I suggested that everything that the police did that day relative to that building should be excluded as a fruit of the poisonous tree. Because the police had been tracking him for so long, because Trooper Telford's investigation built upon each piece of information he gained every day, that as soon as they went to that house, anything they discovered should have been suppressed. This is why I suggest Lottie comes into play. If they had walked up on Mr. Fredericq carrying the brick of cocaine in open view from the car, I'd suggest because they went to that location, specifically as a result of all the legally gained information, with a purpose of looking for drugs, waiting for the data to show them exactly where they were. They went to 220 Howard Street directly after they got the last ping that showed them that they needed to go there. They arrived afterwards. I'd suggest the Commonwealth cannot show any attenuation for police conduct based on everything that occurred at that point.
Lottie draws a distinction between this U.S. Supreme Court case, Cicciolone, where they do find attenuation. Did you go back and forth and look at that part of Lottie?
No, Your Honor, I did not.
Okay, because it seems like it's a tough distinction. Sometimes it's attenuated, sometimes it's not. But anyway, we'll ask your sister. Maybe she's got some guidance on that.
All right,
Thank you very much, Your Honor.
Mr. Levin.
Good morning. May it please the court. Patrick Levin here this morning on behalf of the Committee for Public Counsel Services. I want to thank the court.
Question before you start.
Sure.
Just so I understand the contours of this, is your concern that the common area rule would allow a police officer to come to a multi-unit building, get consent from any tenant in that building, and then be able to search all common areas, and that's just how it works?
No, that is the law, Your Honor.
So is that your concern?
Under Georgia versus Randolph, I think that's a correct statement of law, that where a tenant has free access to all of the common areas and no one else who also has access is standing there saying, no, stay out, that one tenant is able to give valid consent for a search. I think that's right. That's not what happened in this case.
I gather your concern is if no one gave consent.
Exactly. Under the law, as stated in Commonwealth versus Thomas and followed by the appeals court, in this case, the police can just break in the middle of the night, and as long as they don't go into anyone's apartment, the Fourth Amendment has nothing to say about that. And that rule is not only wrong, it's discriminatory, and frankly, it's alarming.
Let me ask you a different kind of question regarding your argument, and that is the United States Supreme Court merged standing and reasonable expectation of privacy. Would that get you to the same place in this case?
Well, I think that at the time that it happened, what you just said is right, but I think it's more precise to say that they have merged the standing inquiry with the question of whether the defendant's individual Fourth Amendment rights were violated.
Right.
And a reasonable expectation of privacy is not the only way that an individual defendant can show that his rights were violated.
Okay.
So based on a sort of new or old, depending on how you look at it, view of the Fourth Amendment that is rejuvenated in cases like Jones and Jardines and Collins against Virginia, that the reasonable expectation of privacy is not the beginning and the end of the Fourth Amendment standing analysis. And the Fourth Amendment, the real point is, the Fourth Amendment is not all about privacy. It also protects security. And that people who live in multifamily houses have a right to be secure in their homes to the same extent that people who live in single-family houses do.
You suggested the police, if there's a common area, the police can walk in. They can't walk in. They got to get into someone has to let them into the building.
They can walk in under Commonwealth versus Thomas. That's exactly what they did in that case. They just walked right into the basement. And this court said, well, that's fine. It's not a search because he has no expectation of privacy there.
But this is more akin to a common area on the third floor as opposed to a basement. So your concern here, I gather, is that if you have something akin to a rooming house, and this is somewhere between a multi-apartment with sub-rentals or a rooming house. Police just can't walk in and sit in the living room and look around.
That's exactly right. And I think I cited in the brief, it's a District Court of Appeals case from Florida, Titus versus State. It's a really excellent opinion, and I would really commend the court's attention to it. Not the Florida Supreme Court did affirm the holding in that case, but the District Court of Appeals opinion is really very good. And I find it extremely persuasive, and that's another rooming house case. And what the judge did in that case is follow a concurring opinion by Justice Jackson from McDonald against the United States, which is a U.S. Supreme Court case from prior to Katz. And the point that Justice Jackson makes is that every tenant in a multi-unit building has an individual constitutionally protected interest in the integrity of the building that is their home. And the police can't just bust down the door and walk in and not be and not have the Fourth Amendment have something to say about that.
But they didn't just bust in here. They are let in. I mean, well, the only illegality, and it may be a significant one, and it may not be attenuated, is the fact that they used the cell phone to get in.
Justice Kafker, you're right.
Proving too much. That I'd like to focus sort of on the facts we've got, which is they're let in to a multi-unit or rooming house.
Well, I will.
And then we get to this sort of marginal communal space. I just think that's hard enough without.
Your Honor, I will speak to that, but I just want to say that I obviously don't represent the defendant in this case, and my argument is somewhat abstracted from the individual facts here. And I think it's clear that this court can easily resolve this case in either direction without even reaching the questions that I'm arguing. And the reason that I asked for oral argument this morning is to urge the court not to, that this is really important and that Thomas should be overruled. And to speak to the facts of this case.
Any other case where the police just sort of walk in illegally? I mean, Thomas is a 1971 case. Yeah. Where they just go into someone's basement or any other examples of that?
I mean, this happens from time to time. You see it in Carriger, that's the Sixth Circuit case. You see it, I think Montañez is a little bit similar in this jurisdiction. I mean, this is something, in terms of the outdoor sort of curtilage situation, there's a number of cases here in Massachusetts. Serbaji is an appeals court case. But the point really is that the rules that Thomas, I guess the real point is when you shepherdize Thomas, you don't get any indication that the rule that is set forth very clearly in that opinion is not good law. And that needs to not be the case anymore. I'm happy to speak further to it, but obviously my red light is on, so.
Thank you.
Thank you very much.
Ms. Kenny.
Good morning. May it please the court, Jessica Kenny on behalf of the Commonwealth. I'm here today asking you to uphold as much of the appeals court decision that did not suppress the drugs. You can do that, and you can maintain decades of good case law developed not only here in Massachusetts, but all across the United States and federally. The defendant simply does not have an expectation of privacy in an unfinished attic crawl space that is being used for storage.
Before we get there, though, I'm confused by the attenuation issue.
Certainly.
So they would never have gotten to this house without the telephone. Everyone concedes the telephone is illegal. How do you get beyond that? I mean, they're not there. They wouldn't know that the guy's there with the drugs. And actually, they know he's there with the drugs because they've got even the latest pinging from Florida, right? So how do we skip over that? And also, I'm just not sure I understand how we get around the case your brother just cited, which it's either Leslie or, I can't remember which case it is, but where if you get there by illegality and it's proximate, in the sense it's close, that we can move beyond that.
So I think what it is very factually distinguished. I don't agree that they only got there because of the pinging. So first and foremost, they're acting under the color of the law as it existed in 2008, and the police are no more violating the defendant's constitutional rights than the trial court judge was that issued the order allowing the police to track the phone.
No one's accusing them of misconduct. The law changes.
It's
right.
certainly a factor for this court to consider. You have to consider the flagrancy. But you get to the attenuation. So the facts are that they turned the phone off driving back north from Florida. And so for a good day, they have no idea where the car is. They know that it may be in the general direction of traveling north, but as they learned along the way, separate and independent, the murder suspect had family in Georgia. There was a concern at one point that they may just stop and reside there with the murder suspect that was there. They had no information about where the phone was until it was turned on, and the testimony was clear just before or just as they were crossing into Massachusetts.
Where does that get you?
So at that point, Detective Williams sends out 2 groups of surveillance units, one to Randolph. And Randolph is an area that 2 of the other individuals that they believed may have been in the car resided. So they had that address completely independent through the homicide investigation, had nothing to do with the pinging. And the second one is the Howard Street address. And they have that address completely independent from the pinging. They have it from the subscriber information, which is still a third-party record, still able to obtain that through the grand jury or through the court order as they did in this case. So completely lawful information that they have, that the phone comes back registered to the Howard Street address. So at that point, as the vehicle is crossing into Massachusetts, it sets in motion what's going to happen for the rest of that day, as long as the car goes either to Randolph or goes to Howard Street. So from that point on, nothing is actually affected by the pinging.
Well,
Police are already on their way to Howard Street.
Don't they, when they confront the defendant up on the 3rd floor, don't they go, hey, we know you've just been in Florida?
That's actually an erroneous finding of the appeals court, and I cited in my memorandum exactly where in the testimony the defendant was confronted by the police and was not told of the GPS pinging, was not given that information, and in fact, it was the defendant that first offered it to them. It was the defendant who said, I just came from Florida with some friends, I just got here, because remember, they're asking him, you know, is anybody in here with you? Where are you coming from? When did you get here? You know, we're looking for so-and-so, and it's the defendant's statement. So that there is not a...
Okay, so say we don't agree with you. We may very well agree with you, but say we don't. I understand you have a backup argument, which is even if, and back to the Chief's original question, even if there was no attenuation, because there's no expectation of privacy, you can take, so even if we have attenuation, I mean, we have no attenuation, illegal search.
Right, which is how...
None of it matters because he had no expectation in the crawl space. Is that right?
Yes.
And that's, the appeals court essentially makes that argument,
And
right?
that's what case after
And
case...
which cases say that? Because he cites a case that goes the opposite way. He cites Lottie that goes the opposite way.
So, I mean, there's a lot of cases in our, so there's Holly, which is the shoebox in the common area in the basement. There's Williams, which is no lock on the basement door, and so...
They're all cases where we have illegal...
Oh, no, I'm sorry. These are all cases that you don't have an expectation of privacy.
I need a case in which you've got an illegal search going on, but the place they're searching is common area or something like that. Again, the only cases I see on point are Lottie, and Lottie references a U.S. Supreme Court case, which I haven't had a chance to look at, that seems to go the opposite way.
Do you have the U.S. Supreme Court?
United States versus Ceciloni.
So, no, I don't. If you would permit me to submit a letter after, I'd be happy to review that and to answer your question directly.
Let's say the police, without a warrant, bust into an apartment. Clearly, there's no emergency, there's no exigency plus probable cause, and it's an illegal entry. And while they're in there, they start to go up on some sort of a footstool, and they go into an area that's clearly not part of the apartment. It's clearly not part of the apartment. And they go up through the ceiling, and they find drugs that they have reason to believe belong to the defendant. What's the result in that case?
I don't know that there's a case on point. So Thomas, again, which was just discussed in the amicus, the police walk in an open, it's a ajar basement door. But there is some information before that. There's information about a tip that drugs are being kept there, and there's a discussion in that case about the need for the police to be able to protect society from unlawful drugs. So there's, clearly there's not probable cause, but they have a tip, and they don't bust in that door, so to speak, because it's ajar and it's open, so in theory, anybody...
But in my scenario, it cannot possibly be that search is constitutionally justified.
Again, under the case law, I mean, granted, I think we've moved well beyond the facts of this case now, so I'm sort of speculating here without having looked directly at that issue, because that's not the issue here. But I would say under Thomas right now, it says that may at worst be a trespass against the building owner, but that the occupants don't have an expectation of privacy in common areas. I mean, and you have to think sometimes, granted, we have I guess you'd call it a 2 or maybe a 3-family apartment in this case, but think about in downtown Boston, you can have 100 complex apartment buildings. You can't say that the washer and dryer unit attached to a 100-unit apartment complex has any more of a privacy right than at that point than a public washer and dryer unit just next door down the street where the public can freely go. So I think, I don't think there can be a blanket rule. I think it has to be very fact-specific, and you have to look at the expectation of the tenants. The Fourth Amendment and the Massachusetts Constitution talks about the right to, retreat to your home and to keep that place to yourself, not to answer the door if you don't want to. And that's not what happened here. It is a crawl space that is, and Judge Walker very explicitly found, he credited the testimony that there was nothing blocking access to that 3rd floor. You walked right up it directly from the door out, the back door at the bottom, and you'd go up that staircase, and you could enter a door into the 1st floor apartment, you could enter a door into the 2nd floor apartment, but the 3rd floor was completely open, and there were a number of rooms up there. And I disagree that it's just his bedroom and this is the hallway outside of his bedroom. It was the defendant's own statement to police that he rented only this room. So we know that, he only rented that room. That's his statement to the police. That's where his expectation of privacy would end. You have photographs that were marked as exhibits. You have testimony from both Troopers Telford and Trooper Walls about the layout. Judge Walker had the benefit of a sketch that was drawn when he made his factual findings. So I think that the record perfectly allows the appeals court to find what they found. But even if this court disagrees with that it can be remanded for that purpose. But I think that it's perfectly developed.
When you say they found, do you mean concluded from the facts, or that they found additional facts?
No, I believe they based their finding on the facts that are part of the record. And I suggest that even though that was never a point raised at the trial court, that the facts were sufficient enough for them to do that.
Let me
Sure.
go back to attenuation. Let us imagine that there was a search of a cell phone with regard to the texts, okay? I know that's not what we have here, but, and let's assume that through that, the police learn that the individual is telling somebody else, I hid the drugs in the base of a tree in the park. Okay, so the police then go to the tree, which is described in the text, and they find a kilo of cocaine. Is the seizure of those drugs prohibited under the fruits of the poisonous tree doctrine?
Directly. As long as there's no other evidence that information came from any other source. And that's why that's not what we have here.
Okay, but there was no search there. That clearly, no one has an expectation of privacy in that tree.
I'm sorry, then maybe I misunderstood. I might have started thinking of the answer before you finished. You said, where did they locate the...
In a park, in a tree in a park. It's hidden, snuck into a...
I apologize. I didn't hear the end of, I wasn't listening quite well to the end of your story, but I would suggest then that there's not a search. Again, you don't have a reasonable expectation of privacy.
Okay, so your argument is that even if the police discovery of those drugs is a direct result of the illegal seizure of that text, it is not a fruit of the poisonous tree unless it is itself a search.
Correct, because you don't even get into that analysis until and unless there's a search.
But aren't there a lot of fruits of the poisonous tree that may not legally be searches in terms of where the illegal information leads the police? I mean, have we ever, I would think that where the police discovered those drugs in the base of the tree or in the cave or whatever, in some public place, it's still a fruit of the poisonous tree, even if it's not a search.
But nobody's rights have been violated because the seizure of those drugs, nobody had an expectation of privacy when they hide their drugs in a public place.
But isn't the violation of rights the seizure of the texts? And we're seeking to prevent the misuse of information that derives from the illegal seizure of those texts. Isn't that the illegality?
I understand the concern of the court, but I still just would continue to say that this case is so incredibly different than that. The things that happen.
Because it's, I mean, if anything, it's certainly the area, the enclosure which was found here is less public than in the base of a tree.
No, I understand, but with regard to the attenuation. So as I was stating earlier with regard to the argument about the attenuation, all the phone told them at that point that set into motion the ultimate seizure of these drugs was that the car was entering Massachusetts. The police were going to Howard Street before the car got to Howard Street. They had set up units and intended to go there, and that is directly from the testimony of Detective Williams at both hearings, that he had sent, I believe he called them assets, to the address in Randolph and the address in Brockton. And I understand that the phone continued to ping. Obviously, it continued to ping even after it was on Howard Street and after it went to the Brockton police station. But the point is that the series of events that set into motion the police action, the only thing that you can say the police gained from that is the timing of when to conduct their surveillance on a public road on Howard Street.
Well, I
and
mean,
the police, if they didn't have the pinging.
But are you saying that they knew that there was a drug deal? They knew that there was going to be drugs in the home apart from the investigative leads derived from the pinging?
I think it would be fair to say that they suspected that there could be drugs when Trooper Telford and Detective Williams started comparing their respective resources and information in their investigations. I mean, remember you had Trooper Telford speaking to an informant about these individuals traveling to Florida and coming back with large quantities of drugs. It was relatively specific about the make and model of the car and where they were going. You had information in Detective Wells's investigation that these individuals, particularly Cassio, the individual they were trying to track, would use either made-up people or straw men as to insulate himself in his phone use. But they knew that Howard Street address from a valid subpoena for subscriber information. And so, I mean, it's hard now to look back and say, what would they have done if this wasn't the state of the law? If it was today and they were looking for a murder suspect and they thought he might be traveling to Florida, and then they had information that when he came back, independent of the pinging, that he might go to Howard Street or he might go to Randolph, I mean, granted, the police probably would have just sat on those two addresses for however long it took until they made an observation that was consistent with the information they were receiving. I mean, so even if you remove any information that they gained from tracking the phone to Florida and then part of the way back up, you still have police officers conducting surveillance on a public street. They were in that area, they were on their way to that area. Then you've got the subsequent stop of the motor vehicle, which was a valid stop based on a motor vehicle infraction. You've got the statements from the witnesses inside. You've got the inspection that the police make of that car, again, consistent with the information. This car looks like it just went on a long trip. There's suitcases and pillowcases and coolers in the back of the car. Those people in the car make a statement that they just dropped off Paco back at the house, and that's the defendant's nickname. So again, as Trooper Telford said it quite clearly, like it was coming together. The information that Trooper Telford had in the narcotics investigation, that the Detective Williams had in the homicide investigation, it started to corroborate itself.
But isn't the phone, it's critical in connecting all of these dots, right? I mean, without the phone, they don't know they're going to Florida. They don't, and they don't know the timing of when they're returning. It gives them all kinds of information. Don't we still have to do those three-factor analysis for attenuation, the length of time between the search and the discovery?
Yes.
The presence of intervening and answer to number one is there's no time, right? It's immediately after, right?
Yes, it's quick.
And the presence of intervening circumstances, are there any intervening circumstances?
There are a number of intervening circumstances.
Which are
the
what?
stop of the independent surveillance of the police, the stop of the motor vehicle that again compounds the information they have, the consent.
Remember, but don't we have to look at the last ping, right? Is literally when they're going to the house, right? It confirms he's inside the house, right?
No, I believe that Detective Williams testified that the last ping that he received was when the car was parked at Brockton Police Station and they were being interviewed. But that he received pings when the car was on Howard Street, and I believe he received pings as it was on its way to the Brockton Police Station. But at that point, the police have already converged on that area. So the police action is to go to that address and to go to the address in Randolph upon the vehicle entering Massachusetts. So it sets in motion what the police are going to do. So it almost doesn't matter where that ping necessarily is, because at that point the police are at Howard Street and they see someone on the front porch of Howard Street. Even if they hadn't seen the RAV4 there, they see someone on the front porch of Howard Street that may resemble their murder suspect, they're going to continue their investigation. You've got a consent search from the first floor tenant, a consent search from the second floor tenant, a valid Miranda and consent search of the defendant himself to search his portion of the room. In the attenuation, all the attenuation cases, the defendant is confronted with the illegally obtained evidence. So there's the musket case where the muskets are sticking out, and they actually say to the defendant, like, what's that? Is that yours? And he says no, and then they go back to the police station and they confront him with the police report of it being stolen. So the defendant, like in that case, knows that the police have seen the illegal item, knows that the police have the illegal report, and that's why it affects his ability to consent, because he knows that the police know something. In this case, Mr. Fredericq had no information that the police had ever been pinging his phone. He had none. He told them he came from Florida. Nothing that they gleaned from the timeline of the trip to Florida and back. They knew the trip was happening, granted not as concretely as they did when they had the pinging, but they had information from sources that they were traveling out of state, particularly to Florida, in a brown, small Toyota SUV, and that they were going to be bringing back large quantities of drugs. They had these videos that the defendant's associates were posting online where they were holding up money and drugs and bragging about going to Florida and bringing back drugs to sell here in the Commonwealth. This was all described in Trooper Telford and Trooper Wall's testimony during Judge Walker's hearing. So all that the pinging gave them was a very precise timeline until they got to the line of Massachusetts and they crossed into Massachusetts. It gave them nothing more. And you can excise the pinging and look at the independent police work and compare that to all the attenuation characters where, again, the police are confronting the defendant with the unlawfully obtained information. And that's why it's affecting his ability to consent or affecting his ability to make a statement. Nothing that the police did here had any effect on the defendant's decision that day to tell police that he rented that room and that he gave them permission to search it. Nothing that they did affected that, and that's why it stands on its own, even absent the pinging that had occurred in the days prior to it.
I mean, your argument could be the same if the drugs had been on the bed. The issue of the crawl space can be completely put aside. You take the three factors of attenuation and address the issue that way.
Which is why our argument at the appeals court was that even the search of the bedroom where the money and the statements that the defendant made should not be suppressed. So as it stands now, the appeals court, the drugs are in play because they were in the crawl space, but the appeals court found that there was no attenuation. But it's always been our position. I'm asking this court to overrule as much of the appeals court that said that there wasn't any. And again, that's based specifically in the appeals court decision. They specifically erroneously say that the police confronted the defendant with the tainted CSLI, that they had been to Florida, and said they knew he had been to Florida, leaving him in a position where he's got to admit it, the police have been tracking me, how can I lie to them now? That is just factually not correct, and that's very particularly indicated in both hearings.
All right, thank you.